I have presided over this courtroom for 23 years. I have seen murderers weep. I have seen innocent men go silent. I have watched families destroy each other over money, over land, over pride. I have heard confessions that made the air in this room feel heavy for days afterward. I have looked into the eyes of people who had done unspeakable things and still managed to sleep at night. But I want to tell you about one case. One trial that changed the way I look at power, at loyalty, at the price a family pays when one of its members decides that ambition is worth more than blood. I want to tell you about Margaret Caldwell. If you followed politics at all in those years, you knew the name. Senator Jonathan Caldwell, 3 terms, ranking member of the Senate Judiciary Committee, a man whose name was floated every 4 years in presidential conversations. Tall, silver-haired, the kind of man who looked like he had been manufactured specifically for a campaign poster. He had the handshake, the smile, the voice. He had the record, and he had the daughter. Margaret Caldwell was 31 years old when she walked into my courtroom. She had her father's jaw and her mother's eyes, and she carried herself the way people do when they have spent their entire lives being told they are exceptional. Not arrogant, exactly. Something quieter than arrogance. A certainty. Like the ground beneath her feet was always going to hold. She was dressed simply that morning. Navy blue. No jewelry except small gold earrings. I noticed that immediately because I had seen enough defendants walk into this room overdressed, underdressed, performing grief or performing innocence. Margaret Caldwell was performing nothing. She sat down at the defense table, folded her hands, and looked directly at me, not at her attorney, not at the gallery. At me. I have thought about that moment many times since. That look, because in 23 years, very few defendants have looked at me like that in the opening seconds of a trial. Like they were the ones doing the evaluating. The charges against her were serious. Witness tampering, obstruction of justice, and the one that brought every camera in the city to my courthouse steps, conspiracy to suppress evidence in a federal investigation. The case had begun 8 months earlier, not here, but in Washington. A federal investigation into a lobbying firm called Stratford Group had quietly expanded until it touched the edges of Senator Caldwell's office. Campaign finance irregularities, payments routed through shell accounts. Nothing proven yet, nothing charged, but the kind of investigation that makes men in expensive suits stop sleeping well, and then a witness disappeared. Her name was Rachel Morgan, 26 years old, a junior compliance officer at Stratford Group who had, according to federal investigators, been prepared to testify about a series of transactions she had personally flagged and been told to ignore. She had retained a lawyer. She had been cooperative. And then one Thursday evening, she stopped answering her phone, cleared out her apartment in Georgetown, and vanished. She was found 11 days later in a motel outside of Columbus, Ohio. Frightened, broke, and carrying a burner phone with a single contact saved under a name that made the federal investigators go very still when they saw it. The contact was saved as M. The last message sent from that number to Rachel Morgan read, "You don't know what you're walking into. Think about your family. Think carefully." It took them 6 weeks to trace the number. When they did, it led back to a prepaid device purchased at a pharmacy in Arlington, Virginia. Purchased, according to the store's security footage, by a young woman in a dark coat and sunglasses. It took another 3 weeks to identify her, Margaret Caldwell. The gallery the morning of opening statements was unlike anything I had seen in years. Every seat filled, reporters along the back wall, a sketch artist positioned near the jury box, and in the 4th row, wearing a gray suit and no expression at all, Senator Jonathan Caldwell, sitting perfectly still, watching his daughter from across the room. I called the court to order, and I looked out at all of it. The cameras waiting outside, the packed gallery, the jury of 12 people who had no idea yet how complicated the next 3 weeks were going to become. And I felt something I don't often allow myself to feel before a trial begins. Eunice, because I had read the case file. All of it. And there was something in it that didn't sit right. Something that felt like it was pointing in 2 directions at once. like standing at a crossroads where both signs said the same town, but the arrows pointed opposite ways. Margaret Caldwell's attorney, a sharp woman named Diana Cole, who had never once in 15 years of practice made an argument she wasn't completely prepared for, stood and told the jury that her client was innocent, that the evidence was circumstantial, that the government had targeted the wrong person in its desperation to build a case against a powerful senator. She said, Margaret Caldwell did not silence Rachel Morgan. Margaret Caldwell was trying to protect. The courtroom went quiet. I watched the jury. I watched Margaret. I watched Senator Caldwell in the fourth row. And for just a fraction of a second, something moved across his face that I couldn't name. And I knew then that whatever this trial was about on paper, the real story was something else entirely. I just didn't know yet how dark that story was going to get. The second day of trial began with rain. I remember that because the windows of the courtroom ran with water all morning, and the light inside had that gray, flattened quality that makes everything feel slightly unreal. The kind of light that belongs in a dream you can't quite shake when you wake up. Diana Cole had promised the jury a different narrative. That morning, she began delivering it. The first witness she called was a woman named Patricia Sims, mid-50s, former administrative coordinator at Stratford Group, soft-spoken in the way that people are when they have spent years making themselves small in rooms full of loud, important men. She sat in the witness box, and she folded her hands in her lap, and she spoke carefully, like someone who had rehearsed not what to say, but how to stay calm while saying it. She testified that in the weeks before Rachel Morgan disappeared, the atmosphere inside Stratford Group had changed, that there had been meetings behind closed doors that weren't on any calendar, that 2 senior partners had begun arriving before 7 in the morning and leaving after midnight, that a particular file, a physical file, not digital, had been removed from the records room and never returned. The prosecutor, a methodical man named Andrew Yates, who had the demeanor of someone who had never once been surprised by anything, objected twice. Both times I overruled him. The testimony was relevant, more than relevant, because Patricia Sims then said something that made the sketch artist's hand stop moving. She said that 3 days before Rachel Morgan vanished, she had seen Rachel in the hallway outside the senior partner's office. And Rachel had been crying, and standing next to her, speaking to her quietly with one hand on her arm, was not Margaret Caldwell. It was a man she identified as Garrett Foster, senior partner, 30-year veteran of the firm, and the personal attorney for the past 11 years of Senator Jonathan Caldwell. I looked at the jury. 2 of them shifted in their seats. One woman in the second row leaned forward almost imperceptibly. I looked at Senator Caldwell in the gallery. He was completely still. Andrew Yates cross-examined Patricia Sims for 40 minutes. He was precise. He was persistent. And he established that she had not heard what was said in that hallway, had not seen what was in any file, and had no direct knowledge of what happened to Rachel Morgan after that day. Technically, he did his job well, but I have watched enough juries to know that technical victories in cross-examination don't always erase what a jury has already absorbed. Patricia Sims had planted something in that room, something quiet and stubborn, like a nail in a floorboard. You could walk over it. But it was still there. The second witness that afternoon was the one I had been waiting for, Rachel Morgan. She had agreed to testify under a limited immunity arrangement. She walked in through the side door, and the gallery leaned forward, almost as one. She was younger than I had expected her to look in person, dark circles under her eyes. She moved to the witness box with the careful deliberateness of someone who had been told exactly where to walk and was concentrating on each step. She took the oath. She sat down. And for a long moment, she said nothing, just looked at her hands on the railing in front of her. Diana Cole gave her that moment. Didn't rush her. Let the silence sit. Then Rachel Morgan looked up and began to talk. She confirmed the transactions, the flagged accounts, the instructions she had received from senior partners to reclassify certain payments in ways that obscured their origin. She described the moment she decided she could not stay silent, the conversation with her attorney, the first contact with federal investigators, and then she described the message. She said she had received it on a Thursday evening, that it had frightened her badly enough that she packed a bag within the hour and left her apartment, that the phrase, "think about your family," had not felt like a general warning. It had felt like specific knowledge. Because her younger brother, she explained quietly, was in the middle of a custody dispute, a very private, very painful legal situation that almost no one knew about. It was not public information. It was not something she had discussed with colleagues. The person who sent that message knew about it. Andrew Yates stood up and very calmly asked her how she could be certain the message had come from Margaret Caldwell specifically. Rachel Morgan looked at him. Then she said, "I'm not." The courtroom shifted. I felt it more than heard it, that collective intake of breath that happens when a trial turns on its axis. Yates paused, tried to redirect. But Diana Cole was already on her feet for redirect examination, and what she did next is the moment I will never forget for as long as I sit on this bench. She asked Rachel Morgan one question. In all your interactions with federal investigators over the past 8 months, was there ever a moment where you told them who you believed actually sent that message? Rachel Morgan looked at the jury, then at Margaret Caldwell at the defense table. Then she looked directly at me the way she had on the very first morning, and she said, "Yes, from the beginning. I told them it wasn't her." The room exploded. I had to call for order 3 times. I watched Andrew Yates stand very still at his table with an expression I can only describe as a man who has just realized the building he is standing in has a structural problem he was never told about. I watched Diana Cole let the chaos settle around her like she had known it was coming, because she had, and I watched Senator Jonathan Caldwell in the 4th row. He stood up, not dramatically, not quickly. He simply rose from his seat, buttoned his jacket, and walked toward the exit with the measured pace of a man who has spent 30 years ensuring that rooms full of people should watch him leave on his own terms. I said nothing. He was a spectator. He had every right to go, but I watched him go. And I noticed something that no one else in that room was positioned to see, because they were all still reacting to what Rachel Morgan had just said. As Senator Caldwell passed the defense table, Margaret Caldwell did not look at her father, not a glance. Not a flinch. Nothing. She kept her eyes forward, her hands folded, her face composed. And in 23 years of reading people in this room, that absence of a look told me more than anything that had been said out loud. It told me she had known he was going to leave. It told me she had expected it. And it told me that whatever Margaret Caldwell was protecting, it was not herself. That night I sat in my chambers, long after the building had emptied. The rain had stopped. The files were spread across my desk. And I kept returning to one question that I could not answer from anything in front of me. If Margaret Caldwell had sent that message to protect Rachel Morgan rather than silence her, why had she said nothing for 8 months? What was she waiting for? I found out the next morning, and I wish I could tell you it made everything cleaner. It didn't. The 3rd week of trial arrived with the kind of stillness that courtrooms sometimes get when everyone in them knows something is about to end, not settle, not conclude. And there is a difference. Conclusions have logic. They follow from what came before. What happened in my courtroom that final week had its own logic, but it was the kind that takes time to absorb. The kind you carry home and set down on the kitchen table and look at for a long time before you fully understand its shape. Diana Cole filed a motion on Monday morning requesting permission to introduce new evidence. I reviewed it in chambers before the session began. It took me 11 minutes to read. When I finished, I sat back in my chair and looked at the ceiling for a moment. Then I granted it. The evidence was a second phone. Not the burner purchased in Arlington. A different device entirely, recovered by a private investigator hired by Margaret Caldwell's defense team from a storage unit in Northern Virginia. The unit was registered under a name that meant nothing to anyone in the courtroom at first, Gerald Whitmore, a name none of the spectators recognized, a name that made Andrew Yates go very quiet when Diana Cole said it aloud. Gerald Whitmore was a former communications director for Senator Jonathan Caldwell's first Senate campaign. He had left that position 18 years ago under circumstances described publicly as a mutual parting. He had spent the years since working in private political consulting, mostly below the radar, the kind of operator that powerful men keep at a careful distance in public and a close one in private. The phone recovered from his storage unit contained 14 months of messages. Diana Cole walked the jury through them slowly, methodically, with the patience of someone who understood that what she was showing them needed time to land properly. The messages documented a coordinated effort not to silence Rachel Morgan, but to redirect the federal investigation entirely. To feed investigators enough information about Margaret Caldwell's movements, her purchases, her proximity to certain locations, to build a circumstantial case that would occupy the government's attention for months, while the actual transactions at the center of the Stratford Group investigation were quietly restructured and buried. Margaret Caldwell had not been framed carelessly. She had been framed with surgical precision by people who knew exactly how federal investigations worked and exactly how long it would take for the truth to surface, if it surfaced at all. And at the center of every thread in those 14 months of messages was a single name, referenced not directly, never directly, but in the way that powerful men refer to each other when they believe no record is being kept: the senator. I watched the jury absorb this. I watched them move through disbelief and into something harder and quieter. Juror number 4, a retired school teacher named, well, I will not use her real name, but I will tell you she had sat in that box for 3 weeks with an expression of careful neutrality that I had respected. I watched her close her eyes briefly, just for a second. The way people do when something they had hoped wasn't true turns out to be exactly that. Andrew Yates requested a recess. I gave him 1 hour. When we returned, he asked to approach the bench. Diana Cole joined him. What was said in that conversation is part of the sealed record of this case, and I will not reproduce it here. What I will tell you is that when Andrew Yates returned to his table, he conferred with his team for 4 minutes. Then he stood and addressed the court. The government, he said, was withdrawing all charges against Margaret Caldwell. The gallery did not explode this time. It went silent. The deep, dense silence of a room full of people recalibrating everything they thought. They understood it about what they had witnessed for 3 weeks. Margaret Caldwell sat at the defense table and did not move. Diana Cole put one hand briefly on her arm. Margaret looked down at that hand, and for the first time in 3 weeks, the composure slipped, just for a moment, just enough. She pressed her lips together and looked at the table, and I could see from where I sat that she was working very hard to hold something together inside herself that had been under enormous pressure for a very long time. I called the court to order one final time. I addressed the jury, thanked them for their service, formally dismissed them. I addressed the gallery. I addressed the record, and then, before I closed the session, I did something I rarely do. I spoke directly to the defendant. I told Margaret Caldwell that the court acknowledged what the evidence had demonstrated, that she had spent 8 months under the weight of charges constructed specifically to destroy her, that she had said nothing in her own defense, had protected no one publicly, had offered no information that might have shortened her ordeal, for reasons that were now becoming clear to everyone in the room. I asked her, for the record, if she had anything she wished to say. She stood. She straightened her jacket. She looked at me with those same steady eyes that had been looking at me since the very first morning. She said, I knew that if I said anything, the evidence would disappear before it could be found. I needed them to believe they had won. 7 words that I have turned over in my mind many times since. I needed them to believe they had won. She had sat inside a federal prosecution, had watched the government build a case against her with materials her own father had helped manufacture. And she had stayed silent, not because she had no defense, but because her silence was the defense. Because the moment she revealed what she knew, the people who had constructed the frame around her would have had enough warning to dismantle the one piece of evidence that could reach them: the storage unit, the phone. Gerald Whitmore, she had held on to that information like a card held flat against the table, and she had waited through the arrest, through the indictment, through 3 weeks of trial. She had waited until Diana Cole determined the evidence was secured, verified, and beyond reach of interference. Then she let it surface. Senator Jonathan Caldwell was indicted 6 weeks after his daughter walked out of my courtroom. Garrett Foster entered a plea agreement within the month. Gerald Whitmore cooperated fully with federal investigators in exchange for a reduced charge. I followed the subsequent proceedings from a distance, the way judges do when a case has left our courtroom but not entirely left us. I read the coverage, I read the indictment, I noted the specific counts and the specific evidence, and I recognized in the architecture of the case that ultimately brought down a 3-term United States Senator, the patient, invisible work of a 31-year-old woman who had understood something that her father, with all his experience and all his power and all his certainty, had not, that the most dangerous person in any room is the one everyone has already decided to underestimate. I have thought about Margaret Caldwell many times since that trial closed. I have thought about what it costs a person to do what she did. Sit across from a parent who has decided that your ruin is an acceptable price for his protection. To say nothing, to endure, to trust that the truth has enough weight to eventually reach the surface on its own, if you can just hold the water still long enough. I don't know what their relationship is now. I don't know if there is one. I suspect there isn't. Some fractures don't have the architecture for repair. And some betrayals, when they come from the direction you least expected, change not just the relationship but the person. They change what you believe is possible between people, what you believe family means, what you believe power is actually made of. What I do know is this: justice is not always loud. It does not always arrive in the moment you expect it, wearing the shape you imagined. Sometimes it is quiet and slow, and it requires someone to carry it alone through a very long darkness before the light finally arrives. Margaret Caldwell carried it. And in 23 years behind this bench, watching people at their worst and occasionally at their best, I have learned to recognize courage in all the forms it takes. Sometimes it looks like a closing argument. Sometimes it looks like a verdict. And sometimes it looks like a 31-year-old woman in a navy blue dress, sitting perfectly still in the eye of a storm her own father created, with her hands folded and her eyes forward, and not a single word to say. Because she had already said everything that needed to be said. In silence, that is the case that stays with me. That is the one I return to when I am asked what justice looks like when the system is turned against itself. It looks like patience. It looks like truth held quietly in steady hands. And it looks, in the end, exactly like what it is: inevitable.